Hello and welcome to Viewpoint. I'm Vladimir Solokhub. More than 2 years ago, after the so-called referendum, Russian Federation annexed the Crimea Peninsula. Following that, the illegitimate Crimean government nationalized state property of Ukraine located in Crimea, as well as some private property owned by various Ukrainian companies. Joining me now to discuss the legal hurdles of recovering the nationalized assets in Crimea is a lawyer, Mr. Yuriy Dobosh. Mr. Dobosh, welcome to Viewpoint.
Hello, and thank you for inviting me.
So, Mr. Dobosh, can you tell us about the nationalization of property in Crimea? What happened and how did it all happen?
Well, recently it's been 2 years since it actually happened, because on March 16, 2014, there was a notorious referendum. Right in 4 days, the Parliament of the Russian Federation passed a law incorporating a new member of the Federation. And the next day, there was a decision of the Federal Council approving that, and actually this was the beginning of the end. On March 30 of the same year, there was another notorious resolution of the State Council of the Crimea, and it was called on the management of property of the Republic of Crimea. And according to its provisions, all the property which belonged to the state of Ukraine, as well as the business of private entities, was nationalized until it is distributed between the Russian Federation, the Crimea Republic itself, and some local communities.
So, Mr. Dobosh, can you explain to us and our viewers why this nationalization is illegal?
Well, it's illegal for many reasons. Well, first of all, the State Council is not authorized neither by the Constitution of the Republic of Crimea nor by its bylaws to carry out such things. Secondly, there must be compliance with the federal law on nationalization and this kind of expropriation. And what happens, in fact, that in the Russian Federation there is no such law which is passed. There are some rumors that there is a draft, but still there is no procedure how to do that. And it was absolutely illegal without any compensation.
So, from the legal standpoint, this nationalization which the Crimean government conducted, it's illegal. But you said that they decided to expropriate the property owned by the state of Ukraine, as well as some businesses, but not all, right? So, what was the approach towards selection of which businesses will lose their property and which won't?
Well, actually what happened, there was the resolution, which I already mentioned, and there was an annex attached thereto, which consisted of the list of the property which was going to be nationalized. And it included more than, well, the last version I saw included more than 700 entities. I believe that there is no criteria, but they decided just to nationalize those assets which are more or less valuable and interesting for them.
So, Mr. Dobosh, can you tell us what is now the solution for, let's talk first about private companies, for the companies, for the businesses to seek justice? What do they have to do and what do they do?
Well, actually there is one effective tool provided by the BIT. This abbreviation stands for the Bilateral Investment Treaty. To be correct, that is bilateral investment treaty between the governments of Ukraine and the Russian Federation on the mutual protection and promotion of the investments. It provides a good instrument of how to protect their rights. And this is the thing which is actually actively used by some investors right now. It provides the opportunity to choose the arbitral institution which suits best to the investor. There are three possible institutions. The first is the Arbitration Institute at the Stockholm Chamber of Commerce. This, by the way, was chosen by State Bank, Bank. And there is a possibility to choose the ad hoc arbitration, the special one, which is especially foreign for a particular dispute. And under the rules of UNCITRAL, Those rules were elaborated by the United Nations Commission on the International Trade, and this is the institution which was chosen by the rest of 6 disputes of the companies related to Mr. Kolomoisky. And there is also the third tool, the opportunity to go to the state courts and the tribunal of the hosting states, as it is called. But obviously, if the investor go to the Crimean courts, they will not find any justice. That's the first point. Their application will be automatically dismissed, and even if they are for some reason successful, they will not be able to enforce that, especially abroad, because there is no single country which recognizes the Crimea.
You said that one of the state-owned banks is already suing the Crimean government. 6 other companies owned by Mr. Kolomoisky are also seeking justice. But you earlier said that there were almost 700 companies on the list which property was expropriated. There were any other cases? So out of these 700, is it only 6 who are seeking justice, or there's more?
Well, the matter is that as of now there are only 8 disputes. Bank, that is Naftogaz, but they're at the stage of the consultation, which is a requirement set out by the BIT for the consultations before the arbitration proceedings. And there are those 6 companies. It is Ukernafta that lost the gas station.
So basically, very, very few businesses are seeking, are going to courts. Why is this happening? Do you think that the other companies do not believe that they can find justice, or that's way too expensive for them?
The answer is quite simple. The matter is that never did this happen before in the history of arbitration, of the investment arbitration, that one contracting state illegally occupied and subsequently annexed part of the territory of another state. And therefore...
But does it have a legal significance? How did the expropriation happen? This is a clear-cut expropriation. And this has happened in many countries throughout their history.
Exactly, but there is another thing, that investment arbitration is quite conventional type of dispute resolution. And one of the peculiar features of investment arbitration is reference to the precedent. And as far as the tribunal are hearing the case and they have no case to refer to, just to check whether they are acting in the right manner, it's quite difficult for them.
Mr. Dobosh, let's talk about the government assets. You mentioned Bank, you mentioned Naftogaz. What about the rest of the property? There was a myriad of various assets owned by the state of Ukraine located in Crimea. Why is government of Ukraine doing something to recover these assets, or to get compensation from either Crimea or Russia?
Exactly. This is a very good point. The role of the state is very important, and it is not possible to overestimate it. Because under the BIT, this bilateral investment treaty, there are 2 possibilities for the dispute resolution. The first is investor against the state, and the second one is state-to-state dispute. However, this state-to-state dispute is only related to the interpretation of the provision of the bilateral treaty. And therefore, there was a decision of the Ukrainian government, and it authorized the delegation for Ukraine and the respective directives to pursue the procedure of, by means of diplomatic channels, of consultation as to what is the territory. Because the investment arbitration is all about the 3 definitions: the investment, the investor, and the territory. The investment is any capital contribution, cash, securities, intellectual property, etc. Everything is also clear with the term of investor, but it is nothing clear with the territory. Because, as you know, there is no single country in the world that recognize the occupation. And after that, there is the resolution of the Security Council of the United Nations, which did the same. And from the perspective of the bilateral investment treaty, it is not clear that, on the one hand, the territory is, from the international law perspective, is absolutely Ukrainian. So what's the point for Ukrainian business?
So basically the Ukrainian government is a very tricky situation, that
Exactly.
if they sue Russia, that will mean that they recognize that Crimea is Russian territory.
That's the first point. The second point is what the investor and the state is trying to do. They say that, well, because Russia says, okay, if that is Ukrainian territory, that the tribunal does not have any jurisdiction competence to hear the case on the merits. But what the investors do? They say that although we fully recognize that it is the territory of Ukraine, but however, temporarily, Russian Federation occupied and illegally subsequently annexed the Crimea and operates and carries out effective control over that territory. And that gives them the jurisdiction, but it's extremely difficult to prove that.
Yeah, it looks like a lot of work for the lawyers. Mr. Dobosh, many thanks for finding time to come and talk to us. We were discussing the legal technicalities of recovering the nationalized assets of Crimea by Ukrainian businesses and government with the lawyer, Mr. Yuriy Dobosh. I'm Vladimir Solup. Thank you for watching Viewpoint.